Good afternoon. My name is Ismail Shahtakhtinski and I'm the principal immigration lawyer at IS Law Firm. In this video, I want to share with you my 10 rules for gathering evidence for asylum case. What type of evidence you can gather, what you should do, what if you don't find evidence in support of your asylum case, how you can do this, and what not to do. So here's what I recommend. So number one rule is that your oral statement and your written testimony that you will provide in support of your asylum application is the number one evidence in support of your case. You can get asylum even without any documents, just by providing your written statement, application forms, and so on, as long as there is a reason why the documents are not there, why there is no supporting evidence, as long as there is a justifiable reason. So don't take this word by word and submit just a written statement and application form. But the take here is, in the number one rule, is that don't focus too much on gathering other evidence and just prepare a random, story or application, or don't focus too much attention on everything, taking away your attention from your asylum declaration and your testimony and your preparation for the asylum interview. So that's number one. Number two, use circumstantial evidence. What it means is that a lot of times it's hard to find any kind of direct evidence, and that becomes suspicious if you bring an evidence of you being, a video recording of you being tortured or being beaten up and so on. That creates suspicion in the eyes of the asylum officers. And generally, objectively, that's, if there is any good, direct evidence, then use that. That's not what I'm saying, don't use it, but use circumstantial evidence, secondary evidence. It could be in the form of letters, documents, or it could be something else that corroborates with your story. It doesn't have to be the direct evidence, like, for example, the police report or the medical record and so on. The better evidence sometimes is to use more of the indirect evidence or more of the corroborating evidence. For example, we used in one of the cases where the client was alleging that he was attending some temple for meetings, religious meetings, where they were subjected to illegal search and they were threatened and so on. We had to get like his Uber receipts, his letter from his employer confirming that he left the job earlier that day, and so on, as a circumstantial or corroborating evidence that this his story is true. So use that. Don't focus only on just trying to find medical records or police statements or police reports. Number three, prioritize the format of the letters, of the statements from witnesses. So if you have a witness, for example, you have somebody who is willing to provide some kind of letter confirming whatever they observed or they saw or they noticed. I'm often asked what is the better format to do so. So the best format obviously is if it's a notarized statement. So for example, if that witness is in another country, in the third country, maybe it will be easy to get a notarized statement from that person confirming that this was indeed the person named so-so who provided this statement. Now, in a lot of countries, the notary is a government employee, so the individual, the applicant, may be hesitant, or the witness may be hesitant to provide such a statement. So what is the next priority? Then get just a letter and maybe attach a copy. The second priority is maybe get a copy of the ID attached to that letter. In one of the cases, we had actually a witness holding the paper, the statement they made in their hand, and there was a screenshot from the Skype or Zoom, I don't remember, and we used that as evidence that this is me who wrote this and I'm holding this, and this was, in the country of the applicant persecution. So, use that. The second priority. The third priority may be, just an email, instant message from Facebook. The bottom line is that there's better formats, but it's, getting something is better than not getting anything from a witness. So get some kind of statement. Rule number four is be creative in getting evidence. Sometimes gathering evidence is not as easy as it sounds, like getting a statement from a witness. The witness may not be willing to give a statement. Sometimes I have clients who tell me that I tried to ask this person if they will confirm, but they refused. They said they're scared. I said, well, how do you know they're scared? How did they convey this to you? How did they let you know that they were scared? Well, I texted on WhatsApp or Facebook, and that's what they said. Well, do you have those text messages from that potential witness who's saying, I'm not willing to be a witness because I'm scared, or just I'm not willing to be a witness? Do you have that? That's a good document. Just screenshot those messages. So be creative. I had a client who had family members who, well, distant relatives who were taking care of his house once he fled. He got some kind of summons, and the summons, he couldn't get them either via email or anything because it was scary. It was a client from Iran, and the summons, it was scary to get those things. So I told the client, how do you know there is this summons? He said, well, my relatives showed it to me via Skype. I said, well, do the same thing and snap the photograph while they're holding those summons. And so that's evidence. So be creative. I mean, there are many different ways to get different types of evidence. Number five, try to keep records of your attempts, of your efforts. So for example, if you have a document that is a key document for your case, but it's missing, submitting evidence that you at least tried is going to be very helpful. And going back to being creative, you can actually, one of the ways to get evidence potentially from your home country is to find an attorney in your country as a member of American Immigration Lawyers Association, or U.S. Attorneys Associations, American Bar Associations. I can get in touch with other lawyers, and I do have contacts in many countries. So probably does your lawyer. So try to get someone there, and maybe they can get evidence. But if they cannot find it, then they can, at least that lawyer, that attorney in your country, can write a letter and confirming that they tried and attempted. Now, let's say if you're not using an attorney, you're asking your relative, your family member who lives in your country, to try to go and get a duplicate of whatever document that you're looking for. You didn't think about getting it when you arrived in the US. Now that for an asylum case you're trying to get. So if they go and the document is missing, get an affidavit from that relative saying that I tried, I was asked by so-so to go get, I went and tried, and that document was unavailable, or whatever. They didn't give it to me, or they said, who are you? So document the efforts that you make to try to get those documents. That sounds funny, but yeah, that's what you should do. The number 6 in my list is keep evidence of how you get the evidence. In a classic example is keeping envelopes of something that is mailed to you. Now, 21st century, a lot of things don't get mailed. You can use email, you can use snap photographs of your relatives could send it. In which case you should keep the headers of the emails. Don't just print the attachment and use it, but also use the email itself, showing that whoever the author, whoever sent it to you, or the same way if somebody sent it to you via WhatsApp, text message, use evidence of that as well. So keep evidence of how you got the evidence. And if somebody's mailing you something, make sure they first scan and email it to you, because mail gets lost, and especially if it's international mail. So make sure that's done. Number 7, use country condition reports. Sometimes the evidence of corroborating evidence of what you're trying to demonstrate is in the country condition reports, in samples of other types of cases similar to yours, or some major events and incidents that corroborate with what you described in your story. So that's also evidence. It's not just evidence of country conditions, but it may actually serve evidence of in support of your story and your specific case. Number 8, do not forge any documents. No matter how important you think it is, or somebody told you, don't listen to somebody who is not your attorney, who is not licensed, is not experienced. Don't listen to anyone telling you that you need to have this, otherwise you're not getting asylum. Again, I promise you, you can get asylum without a single document, as long as you do exercise best efforts to find those documents, and if it doesn't work, you can get asylum. I've gotten asylum for clients of mine who didn't have a single document proving anything in their case, but we did our best to try to get, and we had good reasons why those documents were missing. So do not listen to anyone telling you that you need to have this kind of document. The USCIS has a fraud department that is 24/7 is working on trying to identify those documents, and a lot of those documents from third countries, the U.S. government is aware that could be purchased. Like unfortunately, many of the countries of third world, you can pay to get a document proving that you are dead, and a death certificate for money, or anything, any document you want. So don't underestimate the U.S. government. They know this, and first, it's illegal. Second, it's just stupid to use forged or fake document, or forged record, or forged evidence. So don't listen to anyone telling you should do this. Don't do it. Don't spoil your case. Don't taint it. Just stick to only real documents. Exercise your best efforts to get those. And if you can't get, then get evidence of what you cannot find. Number 8, that was number 8. So don't forge any documents. Number 9, documenting every aspect of your case, going back to me telling you that your story is the most important, your evidence is most important, but also using circumstantial evidence. But documenting every aspect of your case, that's not rule number 9, can actually hurt your case more than help. Again, for the reason being is that who gets every step of their life documented? Sometimes I have somebody who's consulting with me, who's coming to ask me questions whether they qualify for asylum. They have been slapped, and they have medical records showing that they have been slapped. I mean, who goes to a doctor? Because even if it's been punched, unless you have some serious internal bleeding or some kind of alarming injury, people don't go to doctors and medical providers for that. So that creates suspicion. And sometimes I have potential clients who come in and say, okay, this incident ABC happened, and for every incident they have a medical record, police report, a witness statement, like they have this set of documents, a photograph, or so on. They have photographs of police officers, point blank in front of them at the door with the paper file bringing summons. Like, it's very suspicious. Who does that? Well, the police officers who are bringing you summons to arrest you for your political activities, are they going to pose for you in front of your house? And wouldn't that person be scared if that country is the autocratic, dictatorial regime? Wouldn't your whoever relative or whoever snapped that photo, wouldn't they be scared to do that? So, again, number 1, don't use the forged documents. But number 2, which is number 9, rule number 9 in my list of rules, is just so you know that documenting every step, every aspect of your case may hurt more than actually help. And number 10 is that you may not even need any evidence at all. So that ties to number 1, and as I mentioned in the beginning, without any documents, you may be able to get asylum. Only use the evidence that you can gather. Don't sweat over not being able to find other evidence. And if you have asylum, basis for asylum, if you have something that happened to you, if you have well-founded fear of persecution, if you fear that somebody will beat you, arrest you, or hurt you in one way or another in your home country, apply for asylum. Whether you have evidence in support of that is the second question. And that's what I often get asked is, Client says, well, this happened to me, but I don't have any proof, any documents. So should I indicate it in my declaration in support of asylum application? Yes, of course you should indicate. Just because you don't have proof doesn't mean that this didn't happen. And down the road during your interview, this issue is going to come up. Why didn't you mention it in your story? Well, I didn't have any proof. I mean, who asked you to have proof? We said indicate things that happened to you. I mean, who are you afraid of? What kind of harm you suffered in your country? So whether you have proof of it or evidence, we can go through those rules, identify, do our best, and find it. But at the end of the day, the number one rule is that if it happened to you, you have to indicate, you have to include that in your asylum declaration and story. But every case is different. Not every case has the same, obviously, facts and same kind of evidence. There may be types of cases where there is not much evidence required. There may be types of cases where substantial documented evidence, documentation is expected. So talk to your lawyer and go through the process, identify all of that, and if you need help, we will be glad to help. There is our law firm's information is down below. Get in touch with us, schedule a consultation, let's talk about it, and let's see what we can do to help. In either case, we will help you one way or another with your asylum case. And thank you for watching this video, and please sign up and also hit like. Thank you.